Chiogwayo. If you joined us last time around, you will notice that, or remember that we talked about corporate personalities, and in relation to that we talked about like-minded personalities. Like-minded personalities in the sense that we have like-minded persons coming together to start up a business. Well, today we'll be talking about what we call minority protection in companies. Now, minority protection in companies basically relates to the members of the company in terms of when the company has already been formed. We have members of the company being a form of minority owing to the fact that they are not necessarily regarded as the directors or the shareholders, as the case may be. Now, let me start from the top. When we talk about a company, the major personality or the major distinction that goes with the company is the fact that a company is an artificial being. So while we agree that a company is a registered individual that can sue and be sued, we still have to recognize the fact that a company is not a physical being. It doesn't have blood running through its veins. So you can't stab a company if you intend on killing the company. Neither can you shoot the company. So that's why we have the concept of winding up in relation to the dissolution of a company. Now, let's come back to the topic at hand, which is minority protection. Like I was saying earlier, when we refer to a company, we're basically referring to an artificial personality which has been formed by a group of persons termed the promoters. And in this case, the company has been formed with the intention of carrying out business with the purpose of making profit. Now, a company has been formed. How does it operate? Who are the wielding minds? Remember my example last time around when I was referring to a person who buys a car and gives it to another person to drive. But such person who has been wielding or wielded the such authority to drive that car doesn't have the necessary permit or experience to drive the car. There's bound to be a problem. So we'll come back to today's topic in relation to minority protection. And in relation to the example I gave last time, how does it relate to this week's topic? Well, like I said, when it relates to a company, there needs to be a wielding mind that can think and act on behalf of that company. Step in the directors. Who are the directors? Basically, like I've said earlier, the wielding minds of the companies. Like the name implies, directors. Persons of capable, qualified experiences that have been put in positions of authority to direct the affairs of the company, to lead the company to greater heights, to lead the company to achieving its full potential. Now, we've talked about the directors. The next term to be brought in are the shareholders. Who are the shareholders? Some people would say these are also members in the general meeting. But to bring it down, shareholders basically refer to any subscribing member of a company who, at the very least, has in their possession at least a unit of shares belonging to such company that is in existence. And shareholders enjoy certain rights and privileges, of which in later sessions we would go extensively into. But for now, we'll limit ourselves, for the purpose of today's topic, to minority protection. Now, you can consult yourself with the Companies and Allied Matters Act 2020, which is the primary statute in relation to corporate affairs in Nigeria. You can consult yourself with Section 63 of that Act. You can consult yourself with Section 341 of that Act as well. These sections that I mentioned are sections in which the Companies and Allied Matters Act 2020 recognize that there is a need for the existence of directors and shareholders of the company. And in this sense, likewise, the directors are the driving minds of the company, of which they are put in positions to act for the company. Now, why am I making so much emphasis on directors? I'm making so much emphasis on directors because in an instance where there are acts that have been done against the company and the company seeks to enforce its rights in the court of law, who brings such actions to the court? The directors. You guessed right. So you see why it is key, important, tantamount, or paramount, as the case may be, for directors to be able to administer the affairs of the company properly. So many acts and so many decided cases of court recognizes that. Automatic Self-Cleansing Syndicate and Co. versus Cunningham recognizes that fact. Now we come to the matter at hand, minority protection. And when we talk about minority protection, there's one key thing that always attributes itself to minority protection. The rule in First versus Harper. Now, what is First versus Harper? It's actually a decided case. And it's not just any decided case. Some may term it a locus classicus, which basically means a very important case, or that's upon which certain precedents have been set. Now, I'm not going to go into the extended details of First versus Harper, but I'll just give you a summary of what was decided in that case. In First versus Harper, the courts in the UK basically held that when there's a matter pertaining to the company, whether in respect of the company intending its right being breached or not, where a company wants to institute a matter in the court, such matter has to be brought to the court by the directors. And only the directors can bring such a matter to the court. In the sense that it's only a company that can sue on its behalf. Not just any member of the company itself. Only the company can sue on its behalf. So that was what the case of First versus Harper was trying to expatiate on. Now, in the case of the company being able to sue on its behalf, the directors are the wielding mind of the company, and as the people placed in the driving seats of the company are the ones who, in most cases, institute these matters. As such, you can already see that there, in a way, has been a form of, not to use the word loosely, but a form of oppression, or a form in which the rights of the minority of the workers in the company have been repressed to a certain level. And the courts actually took cognizance of this fact. And like we say in law, for every rule, there's always an exception. And now, the concept of minority protection was born out. Now, you would have heard me making reference a lot to the Companies and Allied Matters Act of 2020. That's very important because, like I said, that is the tantamount and most important legislation in the country in relation to the affairs of companies. Now, I made mention earlier of Section 341 of that Act. I make mention now of Section 343 as well. Now, Section 343 recognizes the fact that there are instances where there might be a need to bring matters to the courts, matters in which the company's right has been infringed upon, but whereby the majority of the company choose not to bring such matter to the court. What then happens? In an instance where I and 5 of my friends are directors of a company, and we have 20 personnel working for the company as well, where there's a wrong done to the company, and probably I have a friend of mine on the board involved in such wrong, and I say, oh, we as a board should actually institute an action in the court to ensure that things like this do not happen again. But I say, no, that would affect my friend because he was also involved in this matter. What then happens to the growth and the sanctity and the existence of the company? What then happens to the workers in the company? That automatically puts a strain on the remaining employees in the company, on how they go about their business, and even how fairness or a fair and conducive working environment is provided for them to work in. And as such, even before the commission of a crime, the rights of the minority members of the company has already been infringed upon. And in times like this, the law would not sit idle. And so, what does the law say? It gives out instances where, even as a minority in the company, there are instances where you can actually rush to the court to ensure that those rights are not infringed upon. What are some of the instances? Where the company intends to act illegally or outside the scope of its powers, popularly termed as ultra-vires. In such matters, or in such instances, or in such cases, an action can be brought before the court by a member of the company, irrespective of being the fact that that is a minority, and that matter will be heard. Other instances include when the members of the company want to, by ordinary resolution, make an act which should normally be made by a special resolution. So where the law states, oh, a particular number of people in general meeting need to be present and vote before such decisions can be taken, and you don't meet that number in the meeting, and you want to go ahead and act, such actions already deemed ultra-vires and illegal, and as such, an action can be brought before the court by a minority. And in the same instance, the court would have the necessary jurisdiction to entertain and give judgment on that matter. There are many instances where matters like this can be brought before the court. Now, we talk about instances where minority can run to the court to ensure that their respective rights are not infringed upon. Now, we'll make another reference to the fact that it's not just enough that you have the minority running to the court. When or in what instances or how can these people come to court? Some of the instances include by personal action, representative action, derivative action, and even an action of unfair, prejudicial working environment. go back to the first one, a personal action. A personal action just refers to the fact that where you as a worker in a company sees that there's a right owed to you as a worker that could be infringed upon, or that is being infringed upon, you can actually make an action in the court, and such matter will be entertained in law. And you can seek for necessary compensation as regarding award of damages. In respect of representative action, what does it mean? We have a couple of workers, in whatever number, choosing to come together to make an action on behalf of the company to ensure that the acts or the unruly acts of certain members at the top echelons of the company, making certain acts that are illegal, making sure that those people and their actions do not go unpunished. This is another area where the purpose of minority protection is very important. We'll talk about derivative action as well. Similar state as representative action. In this case, we have the company being attached as a defendant, while the members of the company actually sue those people, in this case the directors, who are engaged in atrocious activities in relation to appropriation of company funds or whatever illegal act as the case may be. Ensuring that those people do not sabotage the affairs of the company. We talk about unfairly prejudicial action in relation to the nature of the work environment. The law also recognizes the fact that every company should ensure that there is a conducive and well-habitable environment for every of its members to work and work actively and work in a peaceable state of mind. Workers can function properly if they have to every time think of the fact that, oh, they have to wake up this morning and go to a place where it's very uncomfortable for them. Workers are not supposed to be treated as slaves. Workers are supposed to be treated as the human beings that they are. And once there is a platform, or lack thereof, for workers to be abused, and there is no appropriate structure for such workers to ensure that their complaints are being heard and being rectified, then they can actually make a run to the court and such actions will be heard. Also, we talk about investigation by CAC. The CAC, which is the Corporate Affairs Commission, the governing body in relation to the activities of companies, can actually come by application of members of the company or even on its own stead. In this case, we term it suo motu, can actually come by themselves and investigate the activities of those companies and ensure that the companies are actually meeting up to the standard in which it has actually provided for in its memorandum and articles of association. And in the case where the opposite is the case, they can actually institute certain fines or necessary actions as the case may be in terms of disciplinary forms. So, in terms of you as a worker, whether listening to this by audio or watching the video, if you feel like you're uncomfortable or you feel like you don't have the necessary rights, or your rights are being infringed upon, and you don't have the necessary ears to be heard, there are ways in which you can communicate this. And a minority protection or a form of that has been made available by the law to ensure that your rights are duly and adequately protected. I'll leave with this. In the conducting of every business activities, as directors, as wielding minds of the company, ensure that you create a safe and habitable space for your workers to work properly and to ensure that they actually have the necessary blanket to be covered from any form of restraint or oppression. This is the only way you can achieve the best in relation to output of your workers. Till I come your way again, have a nice